Hello friends, in this video we're going to discuss about the key amendments which have been provided by or proposed by the GST Council in its 52nd meeting held today on 7th of October 2023. The most important amendment is perhaps on the corporate or the personal guarantee. It is quite frequent that directors provide guarantee to external banks, financial institutions or other persons on behalf of the company. It has been provided that when no consideration is paid by the director, by the company to the director, it would be deemed as if the open market value is zero. So this is a welcome relief in terms of where the personal guarantee is provided by the director. If he is not charging anything, still no GST would be applicable on it. A lot of persons were receiving demand because of this personal guarantee, where it was assumed that some value should be embedded into the value of personal guarantee provided by the director to the company. Next is the corporate guarantee. Intercorporate guarantees, again one more area which is a huge area of litigation. It has been provided that when it comes to corporate guarantee, there will be a new rule which would be inserted, which would provide that 1% of the amount of guarantee which is being provided by the director would be deemed as the value of corporate guarantee, or the value which is the actual consideration charged by the holding company to the subsidiary company or by any of the related entities. So 1% of the value or actual consideration, whichever is higher. This would be irrespective whether ITC would be eligible to the recipient entity or not. So this 1% may become a cost if the recipient entity is not eligible for ITC. Having said this, this rule is going to be expected to be incorporated from prospective date. For a retrospective date, since there was no rule, we are yet to see if there is any specific clarification which comes in. So as of now, corporates need to wait and watch till this rule gets notified. Thereafter, they need to take a decision for both their past periods and their future practices as to how would they be charging their related entities if they are providing corporate guarantees. Next is the mandatory ISD provision. We all know in the 50th GST Council meeting, it was stated that till now, for third party services received, let's say I am receiving audit services and the bill is received by the head office, but the services are received by all the branches. In such cases, ISD as of now was not mandatory, but now it is proposed that ISD would be made mandatory for distribution of ITC. So till now, even cross charge was acceptable. Even if no cross charge was done, it was assumed that the value is zero in terms of the cross charge, and both ISD and cross charge were acceptable. But in the future, ISD is going to become mandatory, and in such cases, it would be important that all the companies who are having multi GSTINs, they can take a note of this particular provision, and they, if required, they can apply for ISD registration at the earliest and start implementing this as a matter of practice, because the government is going to amend the relevant provisions and make the ISD provisions mandatory. So all these cases where a person has multi GST, and they should start planning from now, because by the time this amendment comes in, they may not get sufficient time to implement this whole thing as part of their practice, because they need to also inform their vendors that the invoice now needs to be raised in the favor of the ISD wherever applicable. Next, this is a huge relief, I think, in terms of time barred appeals. A lot of us have been struggling because appeals had not been filed within the due date and even within the extended period. So normally the time limit for filing appeal is 3 years plus 3 months plus 1 month is the extension which is allowed. So if appeal is not filed within this time limit, the department had been regularly rejecting the appeals without any recourse to the assessee other than moving to the High Court. Now a one-time amnesty scheme has been announced, wherein all the all the orders which have been passed on or before 31st March 2023, in all such cases the order, if it has not been appealed, or even if it has been appealed but it has been rejected on the ground that it has been not filed within the time limit. In such cases, filing of appeal would be allowed up to 31st of January 2024. But the only condition is that the pre-deposit would be higher. In this case, the pre-deposit which has to be paid would be 20%, and minimum 2.5% has to be paid. 12.5% would be the amount of pre-deposit, and minimum 2.5% has to be paid in cash. So the pre-deposit percentage would be 12.5% of the tax under dispute, and minimum 2.5% has to be paid from the cash ledger. The other amount can be paid from the credit ledger. So this is a precondition for availing this amnesty scheme. Next, I think a very big area of dispute in case of export of services, that if I am receiving money not directly through FIRC, let's say not directly in foreign exchange, because of which I don't get FIRC, but it is received through vostro account, it is a permissible mechanism of receiving export proceeds as permitted by RBI. So it may be noted that this still qualifies as export of services and the refund would be admissible. But in spite of this being a permissible mechanism, the department had been vehemently denying the refund in such cases. Now it is proposed that a circular would be provided that the refund would be allowed in such export of services cases if the money is received through vostro account. See, normally when I export, it is not always possible that the person who is sending the money would be having a connection with my bank. The sender and remitter bank may not be having a direct connection. So sender bank may not directly give it to the remitter, but they may remit it through another account, which is a vostro account with another bank, which is having a connection with both sender and recipient bank. So in such cases, if the amount is received through this vostro account, even though it is received through INR, the refund would be admissible. This is an extremely good clarification which is going to be coming in for this. Next is the constitution of appellate tribunal. So recently it was stated that the appellate tribunal would be constituted in a lot of places, and thereafter the Madras Bar Association, one of the persons, filed a petition before the Supreme Court that advocates should be considered as judicial members. As a result of which the Honorable Supreme Court issued a notice to the centre, and now this law is proposed to be amended, where an advocate having more than 10 years experience in litigation under indirect taxes can now be appointed as a judicial member. Of course, the eligibility has been prescribed that minimum age of the person should be 50 years, and for president the maximum age is 70 years, and for other members the maximum age is 67 years. Beyond this they cannot be the judicial member. So this is again one more amendment which is with regard to appellate tribunal. Now the law is providing that in certain cases zero rated supplies can be made only with payment of taxes, as a result of which a notification was issued where on certain commodities except like pan masala, tobacco, gutka, export could be made with payment of tax, and only in such products export cannot be made with payment without payment of tax. But when it comes to SEZ supplies, as of now there was no such clarification. The class of persons who are allowed to make export of payment of tax, export of goods, export with payment of tax, or supply to SEZ with payment of tax had to be prescribed, which had not been prescribed till now. So it is proposed that this notification, which provided for export with payment of tax in certain cases, and would be amended. Now SEZ supply to SEZ developer or SEZ unit for authorized operation would be also permissible on payment of tax. So this anomaly which was there in this notification is proposed to be amended. Further, In case of provisional attachment of property, even though it was provided that it would be valid only for 1 year, it required that the order from the commissioner had to be issued before the property could be released. But now it has been stated that the rules would be amended, that DRC 22 itself would provide that it is valid for 1 year, would be valid for 1 year. So automatically after 1 year, the provisional attachment of property would stand vacated. So even if there is no specific order of the commissioner, this would be the case. This would be easing the burden on the commissioner and also on the assessee in terms of following up from the commissioner. With this, I come to the end of this session. I have tried to cover most of the key amendments which have been notified. Of course, there are a few other amendments in terms of rate and exemptions for different sectors, which are also relevant. So this needs to be read very carefully. So I thank each one and every one of you for giving me a patient hearing. I would see you in another video. If you like this video, please like, share and subscribe. Thank you so much.